With the KBLA Talk 1580 editorial, I'm Tavis Smiley. Recently, the Washington Post ran a major story which in sum reveals that racial discrimination in jury selection persists in America. Most often, the practice occurs through a legal tactic called peremptory challenge, which allows an attorney to strike a potential juror without having to state a reason. In the 1986 Batson Doctrine, the U.S. Supreme Court ruled that the use of peremptory challenges to exclude potential jurors solely based on their race violates the Equal Protection Clause of the 14th Amendment. By the way, the late great Supreme Court Justice Thurgood Marshall despised peremptory challenges. New data in the Washington Post story underscores that nearly 40 years after the Batson decision, the problem remains widespread. One study in the Deep South found that black jurors are being challenged and dismissed at double and triple the rates of other prospective jurors. Bottom line, it's racist, it's wrong, and it's pervasive, even as research shows that racially diverse juries spend more time deliberating, make fewer errors, and can result in fairer trials. One of the arguments in the Ninth Circuit Court appeal brought by former LA City Councilman Mark Willie Thomas is about violation of that Batson Doctrine. In its case against MRT, the U.S. Attorney's Office struck black women from the jury pool based on demeanor and employment status, a clear violation of the law. A long list of high-profile black law professors, historians, and justice centers have now filed amicus briefs in support of MRT's position. But the irony of a black elected official who for more than 3 decades represented the best interests of his black constituents having black women voters struck from his jury pool is repugnant and morally wrong. So much for being judged by a jury of your peers. MRT's legal team argues correctly in its filing that given well-established law and legal principles set forth by the Supreme Court, Ninth Circuit, and state courts and legislatures, the Ninth Circuit should likewise reaffirm and clearly state that applying facially neutral justifications in discriminatory ways to target black women and other protected groups presumptively violates Batson. I couldn't agree more. For KBLA Talk 1580, I'm Tavis Smiley. We welcome your comments.